U.S. Bank. I would like to reserve 3 minutes for rebuttal, please. May it please the Court, U.S. Bank is here today arguing on essentially two issues of first impression before the Court. There are, with the exception of one case, which I will mention here in a moment, there's no Florida State Court appellate decisions addressing the two issues that we're here talking about today.
Well, before you get to the substance, can you get me through the procedural? Do you have an order titled Order Granting Summary Judgment?
This is
the body of the order says the motion is granted. The opening paragraph talks about the defendant's amended motion to dismiss and for summary judgment. So you have this unified motion. You don't have individual motions. When it says the motion is granted, to me, that doesn't match the title of the order. The order says granting summary judgment, but the motion says, the body says the motion is granted. So there's multiple motions. There are no findings of fact telling us what the court's basis was. So you want to raise cases of first impression that, from what I can see, in these untranscribed hearings, we don't have an actual ruling by the court. We don't know what the basis for granting the motion was. They raised half a dozen bases.
We did file a statement of proceedings.
The statement of proceedings talks about, we argued the two issues that you're about to raise, the 559 and 24 CFR. You could have argued whatever you wanted to argue. They didn't come in with a rehearing, say, Judge, tell us why you did this. Why did we win? And your rehearing was denied as an afterthought, and we don't even know who prepared the order. So I'm having trouble deciding what am I actually reviewing here other than the argument that you both are anxious to make.
It is part of the argument that the summary judgment that was entered was improper because, as you say, it started out as a motion to dismiss for lack of cause of action.
Well, let's get past that because, you know, maybe they're looking at the clock and they know the banks are sleeping and you're going to miss the 20-day rule, and they played it by the book and they're entitled to do that. I'm talking about what do we review when the order is ambiguous or so generic that we don't know what the court decided, the benefit of the logic. And I'm not saying it's not a final order that we have jurisdiction over. I'm saying what's the remedy you seek other than we want a home run, we want you to say none of this applies, as opposed to you file a whole new complaint, take your chances. The judge didn't give you much guidance, but you have the right to file a new lawsuit.
There is a right to file a new lawsuit, that's for sure. But the dismissal, the defendants, since the borrower was granted summary judgment or the motion to dismiss, as you say, it turned into a final order.
Well, the final summary judgment was never entered.
Because
they argued both motions were granted. They used plural in one of their pleadings, that the motions were granted.
Right.
So how can you grant a motion to dismiss and a motion for a summary judgment? Why would you dismiss something that had been summary judgment out, or vice versa?
Right. It is unclear because of the way that the
I mean, if you don't have an easy answer, I'll figure it out, but I just wanted to see if you had an answer. If not, you can go into your argument. I don't want to detain you.
Sure. Well, okay. I don't know that I have an easy answer to it, but it may become clearer as we go through because a big part of the issues, as you know, are whether the Florida Consumer Collection Practices Act, Section 715, requiring a notice of assignment of the debt, can create a defense to mortgage foreclosure in the first place. And there are no cases that talk about that, state appellate cases that talk about that. And then the second issue is, can the HUD regulations, specifically in this case what was raised, the face-to-face requirement, create a defense to mortgage foreclosure? In both, of course, the bank is arguing that it cannot create a defense. It is not a condition precedent to the filing because the bank is not a debt collector based on the basic definition in the
Well, if it's not
Act.
A condition precedent to the filing, but there's a condition preceding that could be raised in an affirmative defense, even though it's buried in a motion to dismiss. Did the court find that you had to comply with this condition preceding, and was the affidavit sufficient to tee it up?
Part of the big argument is that the affidavit was not competent evidence to even shift the burden. So the court evidently did say that it was a condition precedent, because that's part of the reason why they granted the summary judgment or dismissed the action.
But with the proviso that I don't have Swami-like powers, I don't know what the court actually did. You're telling me that's what it did, but you didn't give me any written evidence of that.
Well, only in the statement of proceedings, that those were the arguments that were made.
And who signed it? Did the judge sign that?
Yes.
Okay.
Yeah. And they were agreed to.
So, I mean, the judge signed off on the arguments being made, but not the gist of the reasoning. The judges didn't agree. That's why I ruled the way I did. I mean, to me, that's an apples and oranges thing. Maybe it's cutting hairs, but I'm still having a problem with that.
Mm-hmm.
But anyway, please go on.
So, of course, since the MSJ was granted, or I understand that this is still the topic of the question, it's de novo review of a summary judgment entered. The borrower's affidavits could not be competent evidence of, if the court is going to require that these are conditions precedent, and I haven't really touched on the face-to-face requirement
you didn't tell us why
yet.
the affidavit is not competent evidence. Does it have to be on personal knowledge and belief?
Exactly. It's on personal knowledge. The affidavit states that the bank, I'm paraphrasing, but it states that the bank did not send the notice. I think the exact words are, did not provide the notice. It does not say that the borrower did not receive the notice. Maybe they would have personal knowledge of that, and whether or not they even say that may not establish. The same with the face-to-face requirement, just jumping ahead to that. The affidavit states that there was no face-to-face requirement. They reside in the property. There's branches within 200 miles. They would not have personal knowledge regarding the exceptions to the face-to-face requirement that could exist. And backing up, even if that is determined to be a condition precedent to the filing of the action, they would not have personal knowledge about the reasonable efforts made to schedule it or the bank locations.
Might it be, though, sufficient if the defendant simply showed that there was no face-to-face, and then the party upon who has a responsibility for doing the face-to-face comes in and says, well, there wasn't one, but there's not an office within 200 miles. I mean, the fact that there's no face-to-face might be arguably prima facie proof of what the debtor needs to show. And she would have personal knowledge of that.
That there was no face-to-face.
That there was no face-to-face.
She would not have personal knowledge about the exceptions, though. And you're right, then if we're at trial, if the bank could come in with that information, this was a motion to dismiss transformed into a summary judgment. I understand it was the 20-day cutoff, and the rule does say at least 20 days. But at the same time, there was information submitted. First of all, there was a verified complaint that says they have the right to enforce, which necessarily encompasses all the conditions precedent.
Yeah, but that's a legal conclusion set forth in the complaint. That's not really a factual, evidentiary, factual assertion.
Sure, but the borrower's duty is to establish with competent evidence that there's no issue of fact that could occur.
Including rebutting the affirmative defenses to a failure to match condition preceding. You'd have to file a defense to their motion to dismiss if they filed an answer with affirmative defenses. You'd have to rebut the affirmative defenses at that point by showing an exception.
Refute it or show that it's legally insufficient. So,
but on a summary judgment, they have to show you don't even have an exception to the defense. There's no possible way to state a cause of action. So it could have been proper to grant this as a motion to dismiss, but not necessarily as a motion for summary judgment. there's two different standards in
Exactly,
evaluating those motions.
exactly.
And
And-
the order doesn't give us a whole lot to figure out what standard the judge approved.
Right, and surely if it was treated strictly as a motion to dismiss, your four corners analysis, it would survive that, or if the court was going to say, and it's clear, it's definitely unclear whether these are conditions precedent or not. There's all these cases, everybody's talking about the cases. If the court was going to come and say, okay, your complaint is dismissed, make your allegation more specific, right to enforce is not enough. We want, it's too general, we want it to be specific, then we could have done that.
Well, you didn't technically allege compliance with conditions preceding. You didn't have that generic paragraph to say we had the right to enforce it. The court could have said, I don't like that, that's not enough. But we don't know what happened.
Sure,
There's no transcript.
The sufficiency of the allegations is definitely subject to each individual judge's interpretation. And some judges will be satisfied with right to enforce, other judges will require something a little bit more specific. That should have been.
Well, apparently there's 400 circuit judges out there that have dismissed these complaints on various permutations of either Chapter 559 or 23 CFR.
Right, or the face-to-face. And I have, did you say 400 or?
I think they've alleged.
Oh, okay,
400.
because of the orders that were attached,
Almost every judge in the state.
and that is something, and of course our time is limited to discuss a fairly complex
We don't
issue.
need to go into the 400.
But bringing up those orders, that certainly, I think, goes to the fact that we really could use a written opinion on this, that the borrower's affidavit could not be competent to establish what is needed to be established to even shift the burden. Because of the timing.
As to what?
As to both of them, actually. The affidavit is not competent as to both of them. They don't have personal knowledge to say whether the bank
doesn't
sent
talk
the
about
letter.
debt collection. It seems like it only talks about the federal regulations.
It doesn't talk about debt collection, but it does talk about that they didn't make any efforts, that the bank didn't make any efforts. They would not have personal knowledge of the bank's efforts. They would not have personal knowledge about the location. Just like in the affidavit also, in paragraph 4, they say that the bank has no standing. Well, the court wouldn't take an affidavit saying there's no standing and just say, okay, that proves your case, and you're done. So it's the same kind of, some of it's factual. Like you said, she knows whether she had a face-to-face requirement or whether she participated in one or not. But whether it was even a legal requirement,
Well,
that
I
is
think
for the
200
court.
miles goes maybe as far as Tallahassee or something close to it. I mean, if she had said she had driven every square inch of that 200-mile radius and she couldn't find a U.S. bank, would that be sufficient?
It would come closer. I still think it would not be sufficient. It would come closer because how would...
The bank attached the screensaver to the motion for a hearing, showing that they don't even have an office in the state of Florida. But that's kind of too little too late. Is that a pleading of record we could consider after the fact on a summary judgment, if in fact this was an order granting summary judgment?
Her statement with the personal knowledge...
Well, if
it
it's
just
not,
lacks the
is it under oath? Is this prosecutable as a perjury if she's lying about the bank having an office in the state of Florida? Normally, you lie under oath, you can be prosecuted with perjury. Do we have that? Or is the statement about the 200 miles precatory? Doesn't it say, as I see it? Does it say there is no, absolutely no, there is an office within a 200-mile radius?
I don't know whether this could be prosecuted as perjury. Certainly, even the statement that she did not receive a notice about the assignment of the loan, the bank has the letter that it was sent. So does she not recall
Okay, but when did that letter
receiving
get
it?
into evidence?
It's not part of the record, you're right.
So you can't really give us that treatment right now.
I'm just saying that the truth of the affidavit of what she actually stated may or may not be, perhaps she doesn't remember.
I mean, you're refuting that the genuine issues of material fact are not genuine, but you haven't given us record evidence to say why they're not genuine.
The bank's argument is that she would not have personal knowledge to make that affidavit in the first place. It's similar to the cases going through the system with prior servicer testimony to try to get business records in. That lack of personal knowledge, they're not even competent as a witness to discuss records of some other entity that they don't know about. And of course, there's gray, how much do they need to know? It's gray, it's not black and white. The same with her. She's not a competent witness to testify to the things that she said. She doesn't even put in here, one of the requirements is that they reside in the residence. She does say in her affidavit that she resides on the property, but the time that's important is whether she resided on the property when they would have filed the lawsuit or when they would have sent the letter. There's more information required than just the bare bones that she sees. Talking about the perjury, she states that she did not get written notice that the debt was assigned to it. The court could take judicial notice. It's not in the statement of proceedings that this borrower had filed for bankruptcy and listed U.S. Bank as one of the creditors. So,
well, your best argument of what is in the record is the complaint.
But, she could show, U.S. Bank could turn up listed as a creditor just on a credit report. If I'm her bankruptcy attorney, I would have been put on the credit report. So that's not necessarily compliance with the written notice requirement.
There is one case, and I'm sorry if I didn't mean to cut you off. I'm not sure my time, my time is.
You're at about 15 minutes, so you got a couple minutes before you get into your 3-minute.
Okay. There is one case I do want to point the court's attention to, which is a 4th DCA case. It just came out September 24th, and it involves the HUD regulation, not specifically the face-to-face requirement.
Is that new authority, or that's one you've cited?
It's, I believe, opposing counsel filed the notice of supplemental authority.
It's been cited, okay.
Real Estate Mortgage Network versus Knight. And in that case, it's dealing with not the face-to-face requirement, but a different HUD regulation, and it's the same kind of situation. They don't discuss what was in the affidavit or the details of what was said exactly, but the borrower's motion for summary judgment was granted, and this court reversed it, saying you still have an issue of fact, even though their affidavit says this.
Did they hold that the CFR was not a condition precedent?
They did not make that holding, no.
In fact, maybe their ruling assumed that it was.
They say that it may be asserted as an equitable defense. So that's when I say that it's a case of first impression. There is this one case that is talking about if the HUD regulations are specifically mentioned in the mortgage and the note, then if it is a condition precedent, and this is the first state case to imply that, still the affidavit is not sufficient to resolve all issues of fact. If there's even the slightest issue of doubt of compliance with the conditions precedent, then that is an issue of fact that cannot be resolved with the affidavit.
What are you asking us to do? What's the bottom line here?
To reverse the summary judgment that was entered for the borrower so we can go back to the lower court and finish the case. Okay. That's what the bank is hoping for.
You should stop if you want to say 3 minutes.
I'll stop there.
May it please the court. I'm Mark Stope, a counselor for the appellee, Carol Morris. I'd like to start with that Real Estate versus Knight case that my opponent ended with there, and note that that was part of the holding of that case was we have held that noncompliance with HUD regulations may be asserted as an equitable defense in mortgage foreclosure proceedings. So the 4th DCA is saying that this is a defense in mortgage foreclosure proceedings.
But you're qualifying as an equitable defense as opposed to a legal defense.
Well, I think that's a distinction without a difference. And understand, if you look at that, look closely at that case.
One requires a lot more proof than the other.
Well,
the fact is, though, that I don't recall whether it was a note or the mortgage or both, that the acceleration provisions specifically referred to regulations by the secretary.
Absolutely, and Judge, and that's what I was getting to here is that in Knight, the fourth DCA ruled there were issues of fact because the bank in that case filed interrogatory answers, so there created a factual dispute. The plaintiff here had no summary judgment evidence in opposition to what we filed at all. Their unauthenticated screenshots attached to their memo is not summary judgment evidence.
The $64,000 question is, did the burden shift where they even had to file a rebuttal? Was your affidavit sufficient? And the key sentence is going to be when the affiant says, as I see it, plaintiff has no excuse to avoid this requirement, and this is talking about the face-to-face, comma, either, comma, as I reside in the property, and plaintiff has a branch within 200 miles of the property, and there's no or. The sentence made me think there was an or, but I can't find an or. And then it says no repayment plan was ever entered either. So there's multiple requirements dealing with a CFR violation of the HUD regulations, as arguably as conditions preceding. And it seems to me these are being teed up as legal issues, not equitable issues. You don't need equitable issues if you have the right to raise them on a legal basis that they absolutely apply. However, there's multiple exceptions to the application of the face-to-face, one of which is the only one that seems to be in contention is the lack of a branch office within a 200-mile radius of the property. So the bare bones assertion that either I reside in the property and plaintiff has a branch within 200 miles of the property, how does that ipso facto establish unequivocally, as is required on a summary judgment, that they have a branch within 200 miles?
Well,
forget the fact that the reality is they may not even have a branch in the state of Florida. Let's ignore that affidavit altogether attached to the motion for rehearing.
Sure. A couple of reasons, Judge. The first answer to that is based on the questions that you were posing to my opponent, which is they don't have anything showing that they even preserved this argument below. They argued this as far as the record before Your Honors is concerned.
Time out. There is a stipulation. She said the judge approved.
Right, but the stipulation says nothing about the argument about the sufficiency of this affidavit. They're challenging this being made on personal knowledge or challenging this.
There was no motion to strike the affidavit.
Not even an argument saying that there was no personal knowledge to make these, not an argument saying this is hearsay, nothing at all until the briefs.
But the affidavit may or may not be defective. If it's defective and insufficient, that's a legal issue. If that's competent proof, the judge gets to make the decision, yes or no. But if it's incompetent proof to establish what it alleges, then the judge can't give it the force of law.
To answer your question, the way I read this, it says, as I see it, plaintiff has no excuse to avoid that requirement. So her statement, as I see it, modifies that phrase. And then it unequivocally says, I reside in the property, which eliminates one of the exceptions, and plaintiff has a branch within 200 miles of the property, which eliminates that exception.
So the word either, we just excise out the word either.
Well, as I see it, plaintiff has no excuse to avoid that this requirement either. The requirement referred to in the previous sentence of making phone calls or providing letters or giving the counseling. And it makes unequivocal statements of, I reside in the property and plaintiff has a branch within 200
your
miles.
Your argument would fit better if the affidavit had the typical opening that said, on personal knowledge and belief.
That's in the first sentence, Judge, first paragraph.
Read it.
I am over 18 years of age, competent, and state these facts upon my personal knowledge.
Okay.
So I think that at minimum shifts the burden to them to come forward with some sort of opposing evidence, and they came forward with nothing. Now, I'd like to go through this FHA analysis because I think...
Okay, but what is the personal knowledge that there's a bank within 200 miles? I mean,
well,
is that enough to just say they have a branch within 200 miles?
Sure, Judge. She knows where her house is. She lives there, and she's saying on personal knowledge she knows that there's a branch within 200 miles.
But what's the address?
Well, I don't think... Could it be better if the address was in there? Sure, but I don't think that's necessary in order to shift the burden to them to come forward with some opposing summary judgment evidence, and they just didn't. Now, I think that I want to start with contracts are construed in accordance with their plain language. Mortgage foreclosure doesn't...
Just to follow that thought. So the remedy you seek is an affirmance with an opinion to say, yes, the HUD regulations apply, and they are conditions preceding, absent an exception, and they file a new lawsuit.
Or an affirmance that just says affirm.
Well, I do think that this situation is ripe for a published decision, which might sound odd as an appellee to say, because this is an issue that you can see from the orders I've provided, both issues, 559 and the CFR. I have won on a ton of times. I have 40 different judges who have won on before on the 559 issue, but without DCA decisions, there's certainly not unanimity on the circuit court level.
It doesn't
Now,
seem like the judge spent a lot of time in the order dealing with the Unfair Debt Collection Practice Act. The bank was seeking to foreclose. They didn't even seek a deficiency judgment in the pleadings. Is that correct?
Judge, look at the complaint again. My recollection was that they reserved jurisdiction for equitable orders as may be appropriate.
But but where are the allegations in your motion to dismiss or anywhere else or in your affidavit showing that they had actually engaged in collection practices that would have elevated them to a debt collector as opposed to a bank trying to get back the security interest?
Judge, I'm sorry, the issue of being a debt collector is wrong and is a red herring. This court said so in the Gann decision. The holding of that case was that the FCCPA applies irrespective of whether you're a debt collector. Florida courts have recognized the FCCPA applies not only to debt collectors but also to any person. That is the established precedent of this court from just a few months ago.
So you're saying that establishes it without regard to the pleadings or the facts?
Well, I'm saying that
I'm not sure that Gann says.
I'm saying that they don't have to, that this bank does not have to be a debt collector for the FCCPA to apply. I think the case very clearly holds it overrules Trent, the Middle District of Tampa decision my opponent relies on.
I don't think we can overrule the federal.
No. I'm saying that the Second District followed the 11th Circuit cases which overruled Trent. The 11th Circuit came out with 2 decisions in 2012 which overruled the Middle District of Tampa case.
Isn't the state statute modified after the federal counterpart?
Yes, but the state statute is actually
You're
more...
not alleging a violation of the federal statute, are you?
No, this was a violation of...
How come? Why aren't you alleging a violation of both to be on the safe side?
Well, the state statute 559715, the notice provision in that is the FCCPA is set up in some respects to be more restrictive than the federal counterpart, which is the state's prerogative if that's what it chooses to do. 559715 requires, if you're not the original creditor, that you have to give written notice at least 30 days before any action to collect a debt. Gann says that mortgage foreclosure is an action to collect a debt. That is the holding of this court's decision in Gann.
Under the facts of that case.
Well, I don't see how you could say that mortgage foreclosure is an action to collect a debt under the facts of that case, but mortgage foreclosure is not an action to collect a debt under the facts of another case, respectfully.
Well, you can. If the facts are different, that's what the facts are for.
Well, but mortgage foreclosure is mortgage foreclosure. Like the facts in this Gann case, there was the paragraph 22 letter. The holding was that the paragraph 22 letter, which is the condition precedent in any standard Fannie Mae mortgage foreclosure suit, that the giving of that letter constituted an action to collect a debt. Well, that happens in all of the Fannie Mae mortgage foreclosure
Did you
suits.
have that in this case?
Well, no, because this is not a Fannie Mae mortgage.
Right, 90% of loans are Fannie Mae, and they're not governed by HUD regulations.
But the cases that I have cited, I think all uniformly hold that mortgage foreclosure is an action to collect a debt within the ambit of the FCCPA, and that leaves the only issue of does this operate as a condition precedent? And I think that it has to, because the statute requires on its face that the notice be given 30 days beforehand. To ignore that is to ignore the plain language of the statute. Now, I've occasionally had people argue, well, you could file a separate suit as the consumer, so that should be your remedy. But that's not true, because if you looked within the Act, the Civil Remedy Statute 55977 authorizes a separate suit for violation of 55972. But not for 559715. So you can't bring a separate suit for violation of 559715. So what is your recourse then? It has to be defensive. It has to treat the statute as a defense. Because if you don't treat it as a defense and you can't file a separate suit, then there is no recourse at all. The legislature doesn't write meaningless provisions. The only way to enforce that provision that requires the notice to be given 30 days beforehand is to treat it as a condition precedent, as 40 of your colleagues have done.
Or you file a complaint.
Well, but Judge, you can't file a complaint.
A complaint in the form of a letter or something else with one of the people in power to rectify it by saying, go to school and do things better next time.
Well, I don't think that is the recourse here. I think the recourse has to be either to enforce the statute, you either can sue or treat it as a defense. Where the act doesn't allow a suit, it has to be treated as a defense. I cite on page 39 of the brief several cases where, including U.S. Supreme Court case and a 4th DCA in-bank decision, which treats statutes as conditioned precedent, even where the statute doesn't expressly say it's a conditioned precedent, where it required a notice to be given or something to be done a certain number of days before you have to file a suit or take an action. That's precisely what we have here. Those cases are on point. I also want to go through the argument on the merit of the CFR issue. We have a contract, paragraph 6 of the note and paragraph 9 of the mortgage, that specifically require compliance with the HUD regulations before accelerating and before foreclosing. It's basic contract law that has to be complied with. You know, I think what's most telling here is that I argued in the answer brief that in the last 35 years, there is not a state in the country anywhere that has said that is not a conditioned precedent. I cited Virginia, Indiana, Pennsylvania, Iowa, California, Ohio, Illinois, Colorado, and New Jersey, all which went my way on this, and the 4th DCA by my notice of supplemental authority. And I said there's not one state anywhere that goes the other way. Their answer brief, even when I made that statement, their reply brief, still didn't cite a single case that went their way on that, even when I made that statement. The law is uniform on this FHA issue because it's a basic matter of contract law, and it's not just an equitable defense, it's a legal defense.
Well, I mean, if the bank expects for the government to pay a bad loan off, they need to do the legwork, and I think that's a policy issue also.
Exactly, and that's part of my argument here, and some of the cases make that ruling. Lacey, Indiana, Pennsylvania, Iowa, they say if you as a lender want to enjoy the benefits of this government-insured loan, then you have to do what the government says, which is comply with the face-to-face requirement of this regulation. Now, my opponent cited some cases from before 1980, before this regulation was codified into law by Congress. Those cases don't apply anymore, and some of the cases that I've cited in the briefs make that distinction. Some of the cases also explain how important it is as a policy matter to prevent foreclosure in FHA mortgages because these mortgages were given to low-income families. Here, the prevention of foreclosure in HUD mortgages whenever possible is essential. The HUD program's objectives cannot be obtained if HUD's involvement begins and ends with the purchase of the home and the receipt of a mortgage by a low-income family. So not only is this a conditioned precedent, this face-to-face counseling in an FHA mortgage.
Well, let's assume for the sake of the debate, it's a conditioned precedent. The question is, and I think you would agree, if it's a conditioned precedent and the bank was able to show one of the exceptions, you wouldn't be disputing that as a reason not to comply with the face-to-face meeting.
Right. If there was
so we're down to the affidavit. Does the affidavit carry the burden of showing that no exception applied?
Absolutely. The 5 enumerated exceptions are spelled out in my brief, and the affidavit conclusively disproves each one of them. We show that we resided in the property. You
say all of that, but is that proof saying something? Does that make it so?
Well, sure. A sworn affidavit, the summary judgment rule authorizes, 1.510 authorizes affidavits as summary judgment evidence.
Well, I just said the sky is yellow. I'll swear to that. Makes me a liar, but does it make the sky yellow?
I hear what you're saying, Judge. Well, for purposes of the record...
You're arguing as though I have to take it as gospel. I don't think a judge does.
Well, I think that you have, on the facts, on the record that was before the lower court and is before this court, there were and are no facts in dispute. We showed that the counseling didn't take place.
Every single fact that's not in dispute, with the order being as generic as it is, we have to take each and every one of those facts, even though the court didn't make a comment, which one it believed or didn't believe.
Judge, summary judgment, the court can't resolve fact issues.
Sure, there are no factual disputes to resolve at summary judgment. The court...
So there's either a fact issue or there's not, regardless of whether we believe it.
Sure, and there were no fact issues here because they didn't file anything in opposition to this, and our affidavit was competent, and they didn't preserve any argument that it was somehow insufficient or not based on personal knowledge or anything like that, and there's nothing in the record to establish that. So they have no basis upon which to ask this court to reverse at all. So on the FHA issue, the case law is just overwhelmingly in our favor, but I submit that we do need a decision that says that that follows all the other jurisdictions from throughout the country that says this is a defense in foreclosure in an FHA mortgage. The party's own contract says so. That's what this court has been doing for years in the paragraph 22 context. Paragraph 22 in the standard Fannie Mae mortgage, you interpret that as a condition precedent because the contract says so. Here, the note in the mortgage say you can't accelerate or foreclose unless you comply with these regulations. It's really the same thing. The only reason we don't have law on this yet is because the overwhelming majority, probably 90% of mortgages are Fannie Mae mortgages, and probably only 7 or 8% are FHA mortgages. But I submit that that is an appropriate ruling. A PCA is also an appropriate ruling if you don't want to do it in this case, but clearly there's no basis to reverse based on the FHA, and an affirmance is also appropriate on 559715. That is another issue for which the circuit courts need some guidance, and I submit there's no basis to reverse on that. There are no facts in dispute. This plaintiff was not the original lender. Our affidavit in paragraph 3 shows.
Well, let me ask you a question. I mean, they filed a complaint. The complaint said they without paraphrasing, they hold the note, let's say, and that payments haven't been made since a certain date, which is years after they started getting the note. So if there was payments made to them for so many years, how can you turn around with a straight face saying you don't know they don't have any standing to foreclose on this, or you don't know what their identity is?
Couple of reasons. One, there's no summary judgment evidence that payments were being made to them at all. That's an issue that I addressed in the briefs. Okay, and two,
they didn't move for summary judgment.
I'm sorry?
They did not move for summary judgment.
Right, but the fact that you're asserting is not a fact that exists on the record here. The fact
It's in
that
the
exists.
complaint, but you got the Four Corners rule.
Okay, but that's not a motion to dismiss.
You have to accept
Sure.
that as well.
Not
True.
for a summary judgment motion. For summary judgment purposes, we conclusively showed that this plaintiff was not the original lender and did not give written notice.
So you're saying when you combine a motion to dismiss and a motion for summary judgment, you can have inconsistent factual allegations?
No, I'm not saying that.
You have to accept.
What you're saying is the notice wasn't given.
Absolutely. What I'm saying is that I realize, obviously, a motion to dismiss and summary judgment are separate standards. There's nothing that prevents you from bringing them within the same motion while still arguing them as separate standards. We argued this summary judgment motion based on 559715 as a separate standard if they did not give the notice. That was conclusively established. The bank presented nothing in opposition to that, so there were no facts in dispute about the giving of the notice.
I don't recall. Was there a servicer in this case other than the mortgage holder?
There's no summary judgment evidence from them on the servicer issue.
Even in the completings?
What the complaint showed is that U.S. Bank National Association was not the original lender. Market Street was. They alleged that there was an assignment from Market Street to U.S. Bank, the plaintiff, the appellant here. Their own brief acknowledges that assignment of mortgage in the statement of facts, but one of the issues we prevailed on is that there was no notice of the assignment of the debt to my client. That was conclusively established by our affidavit, and they had absolutely nothing in opposition, which only left the legal issue on whether the statute applies. It applies.
Is the assignment necessary once you start paying someone, or does that waive the issue of assignment where there's a factual question?
Well, I submit, Your Honor, there was no evidence that someone had been paid, but even if there was, the notice of assignment is still necessary because who they were being paid to could have been a servicer or a third party collecting on behalf of the assignee of the debt. And the Burt case, the only published decision that cited 559715, makes clear it's notice of the assignment of the debt that has to be given, not a notice of change of servicer. Notice of change of servicer is an obligation under RESPA, a totally different federal statute.
Oh, we don't have that.
Sure, totally different concept. So to answer your question, it had to be a notice of assignment of the debt, and I see them all the time. It's a simple letter or notice that says, they're usually called notice of assignment, and it says, here, it's a notice showing a notice from the plaintiff that's suing to the homeowner saying, we own your debt, this is our debt now. And it didn't happen in this case. The evidence was conclusive on that. That's why I spent a lot of time in the briefs arguing the legal issue, which is what I think we need guidance on. Gann says mortgage foreclosure is an action to collect a debt. There are lots of federal cases that now say that too, as those 11th Circuit decisions that this court followed in Gann. That's pretty powerful stuff. The 40 judges who I've cited in my notice of authority before this court. The only issue, quite frankly, where I occasionally encounter argument of, well, is this really a condition precedent that I want to be clear on? I don't see how you could treat it as anything other than a condition precedent, because what they want you to do is ignore the statute. I know we didn't give the notice, and then the statute requires it to be given 30 days beforehand, but let us sue anyway. They want you to ignore that. The legislature doesn't write
I mean, just not to parse words, I think what they said was, the record doesn't establish that we didn't give the notice. If, at most, it only establishes the debtor didn't receive the notice.
Our affidavit, paragraph 3, it did not give me written notice that this debt was assigned. The statute requires the notice be given. It doesn't require the notice be sent. This is not like paragraph 20.
Where's the personal knowledge? I mean, that read as a whole.
She knows whether she got one.
Right. She's saying, you didn't give me the notice. She certainly has personal knowledge of that. They waived that argument, an argument otherwise anyway. And that's what the statute requires. The legislature didn't write a statute that required the notice be sent. It wrote a statute requiring the notice be given. So when we file an affidavit that says they didn't give me the notice, that's directly on point and shifts the burden to them.
Knock on the door and say, here's your notice?
Judge,
Here's your sign?
I get that the word give in this context is, I leave it up to your honors to define that.
If your burden is to send it, you can just drop it in the mail. If your burden
Sure.
is to give it, you're saying then what they really need is a certified mail with signature required.
I think that's very fair. It's not give doesn't mean sent. If they meant sent, the legislature would have written sent.
Or knock on the door.
Sure, and I want to be clear that we're not confusing that issue with paragraph 22 of the standard Fannie Mae mortgage, which has a paragraph 15, a contractual term that requires that the notice only be sent.
Right.
So you've probably encountered this issue. This statutory obligation is to give the notice. Our affidavit conclusively showed that this plaintiff did not give the notice. That put the burden on them to come forward with something, and they came forward with nothing. So as a factual dispute, we locked this down. That made the only issue a matter of law, and I don't see anything. What's their case to the contrary of what I've presented? The Trent decision out of the Middle District, 2007, that was overruled by the 11th Circuit. They don't have anything to the contrary as a matter of on a legal issue.
Okay, between the two of you, I haven't had many words in edgewise, but I need to mention that you're out of time.
Thank you all, Your Honor. The order should be affirmed. Thank you all.
Thank you. Just a couple comments on rebuttal.
Tell me why Trent should still be good law in view of what he's saying. He said it's been overruled by the 11th Circuit and by Gann.
The cases that appear to come close to saying that the lender could be a debt collector involve, by and large, I don't have the whole list in front of me, that mortgage foreclosure could be subject to it, but the cases that discuss it deal with separate civil actions, like, say, against the law firms. It could be related to the foreclosure action, but the actual filing of the foreclosure has not yet really been clarified. Trent is still cited for that proposition by a lot of courts.
So you're saying, like, if there's a lawsuit alleging some sort of liability for violating.
Right.
But in order to predicate a lawsuit on that, you would have to determine that the foreclosure of the mortgage involves the collection of a debt under the statute. And if that's the case, wouldn't it apply otherwise? So what you're arguing is it's not a defense to the foreclosure, even though the bank would be collecting a consumer debt under the statute.
Certain letters and things that are discussed in those cases, the default letter, the letters that the firms usually end up attaching to the complaints, those letters are asking for money. So it's the collection of a debt. When you file the foreclosure suit, exactly. It could, and even though it could be imminent, but the actual filing, you're no longer asking for the money. Now you want the return of the secured property. But even if that is considered, I do recognize there are cases out there that seem to say it could be an equitable defense for the HUD, not so with the notice of assignment. But the sufficiency of evidence argument regarding that affidavit is not waived. In the summary judgment rule itself, it talks about that the judge, without any action on our part, if the affidavits are unavailable. We did have a verified complaint. The default letter was filed. There were bank locations listed, which were websites. The court could take judicial notice of that. The summary,
That was on the rehearing.
that was
That was on the motion for rehearing, right?
in the opposition to the summary judgment that was filed, not just on the rehearing. Yeah, that was beforehand. And the rule provides that the court can determine that if the other side needs more time to get an affidavit, we didn't have an official affidavit because of the timing requirements. 20 days is just not long enough for the bank to.
Under the rules, that's,
Sure.
I think the rules assume that it's long enough, because you didn't ask for more time.
But the standard is that the court has to look at the whole record, and between the verified complaint, the default letter, the location information that was provided, that still should establish there's an issue of fact going on here. The sufficiency of the affidavit, sufficiency of evidence is never waived. The 1530 specifically states that you can still raise sufficiency of the evidence, even if not raised before. And I was not the person who was there, and I know the statement of proceedings is just sort of vague about saying that it was argued that there still is a genuine issue of fact. Well, that's related to the insufficiency of the affidavit in the first place.
Your time is up, too.
Thank you.
Thank you both very much.